And then depending on what type of an employer you are, you either comply with the Federal Fair Labor Standards Act or the California Labor Code on wage and hour. So the good news is the California laws on overtime and regular rates of pay is actually more liberal than the Federal Fair Labor and Standards Act. So if you comply with the California law, in essence, you are actually complying with the federal FLSA. This is why you won't see that much of a discussion on the FLSA, because it's actually more restrictive. And I'll kind of point out some differences. But basically, our wage and hour laws regulate a couple of things. Number one, the actual minimum wage that we have to pay employees. So in 2019, the minimum wage is broken down to whether or not you have 26 or more employees, and then whether or not you have under 25. So for example, in 2019, I believe the minimum wage is $11. And then in 2020, it's gonna go up to $12. But then one of the things you need to keep in mind is that different cities have their own municipal ordinance on minimum wages, and it could be higher than the California Labor Code. So the major cities that have their own minimum wage, basically they're the major cities: San Francisco, Los Angeles, San Diego, San Jose. They have their own unique minimum wages. So depending on where your client is, not only do you have to check the labor code, but look at the municipal ordinance where they're situated to see if there's a local minimum wage. The other thing that California regulates are meal breaks. Under California law, if you are a non-exempt employee, you are entitled to a 30-minute meal break if you are scheduled to work more than 6 hours a day in a workday. So if you have to work more than 6 hours, you have to give your employee a 30-minute meal break. And the tricky part that most employers make a mistake with is that they schedule it too late in the day. So under California law, you need to schedule your meal period no later than the end of, I love all those prepositions, the end of 5 hours and 59 minutes. If you schedule that lunch break at the 6th hour, you violated the law and you owe them a 1 hour premium. So it's 5 hours and 59 minutes. You have to schedule that meal break no later than at the end of the 5th hour. The other thing that California allows for are rest breaks. So generally in an 8-hour day, you're entitled to 2 10-minute rest breaks. Every 4 hours, you get a rest break. So in the morning, you should get a 10-minute break. In the afternoon, you get a second 10-minute break. The great thing about rest breaks is that as an employer, you're only required to give employees an opportunity to take that break. They actually don't need to take it. If the employee chooses to work through their rest break, it's not a violation of the law. Your obligation as the employer is to make sure that you give them that opportunity. If they decide to work through it, it's completely fine. And then the overtime rules, which are so confusing and critical. Overtime rules apply depending on the classification of that domestic worker or that caregiver. But the general overtime rule is this: if you work more than 8 hours in a day or over 40 hours in a work week, you have to pay time and a half. So the key point is 8 hours or over 40. I'll contrast that with the Federal Fair Labor Standards Act. Under the FLSA, the overtime rules are actually more generous. Overtime applies at anything over 40 in a work week. They do not have daily overtime. In the federal law, it is weekly overtime. In California, we have either daily overtime or weekly overtime. And under the federal law, actually the federal law doesn't even have a meal break section, and they don't have a rest break. So most of the other parts of the country that have just the federal law, there's no mandatory meal or rest breaks. Okay, so at this point, I'm going to hand it over to Debbie, who will give you an introduction on the Domestic Worker Bill of Rights.
I think I'll just sit here to get this kind of moving, but I just want to reiterate what Kristine said. In Los Angeles, currently, the minimum wage is $13.25 if you have less than 26 employees, and it's $14.25 if you have more than that. So it's different in every city, and the cities are starting to have their own ordinances. So you really do have to check those ordinances when you're looking at what the minimum wage is and how you're going to compensate employees for overtime. And it applies to employees who work in the home. So what typically happens is a person will hire somebody that they like, and they'll pay them either a flat rate per week, or they'll pay them hourly, but they won't pay them overtime, or there's no record of their hours. So once the trustor dies, the employee says, oh, I worked 15 hours a day. Well, who's going to say that they didn't unless there's somebody who's monitoring what's going on? And it opens the trust up to a huge claim for back wages. And we're seeing more and more of that happen. There's law firms that are specializing in looking for caregivers who have claims against an estate, or even just a person who's they're currently working for. It doesn't necessarily mean the person's died, and they're going after the trust after that. Since the recession, which I always found hard to believe, the California legislature has been very active in the employment area. You would think that when you have a recession, you don't want to drive employers out of the state, but somehow that's not their mantra. So in 2014, they passed the Domestic Worker Bill of Rights, and it was meant to give some rights to people who work in the home. And it went into effect then, and it basically just gives them general protections. It's for people who provide services to an individual, like bathing, feeding, directly to that person. And it's also for people who work in the home and do the laundry, make the meals, and all that type of thing. So what they did is they basically said, we're going to go ahead and put this in a statute and codify how we want you to handle employees who work in the home. So prior to that, we had a category called personal attendants. And they basically were exempt from some of the wage and hour laws, but there was a very specific definition for that. And that person has to, I don't know, maybe I should be not good at this. Okay. Has to care for the person in the home, or basically make meals and take care of the person. They can only take care of the individual. They can't be spending more than 20% of their time doing laundry, making meals in general. So it's important to determine whether or not, first of all, the person that you have working for you is a personal attendant. So feeding, bathing, dressing, direct supervision of a person. So typically if you have a person who's very ill, that person that's taking care of them is probably going to be a personal attendant. But it's a very tricky aspect of the law, because how do you prove that that's what they did and they spent less than 20% of their time doing anything else? So we'll talk about some ideas later about how to resolve that. But if you're a personal attendant, you can be paid overtime after 9 hours instead of 8. Kristine mentioned that there's overtime in California over 8. And you can be paid or over 45 in a week. So it gives you a little bit, gives the employer a little bit of protection in terms of overtime, but you still have overtime liability. Now, if you have employees who work in the home and they're not personal attendants, that means they're not spending at least 80% of their time feeding, bathing, dressing, and directly supervising the individual that they're taking care of, then they fall into the regular employee category, where they get 8-hour overtime over 8 hours in a day, or 40 in a week. But it depends on, under the Domestic Worker Bill of Rights, it depends on whether they live in the house or whether they don't live in the house.